Assalamualaikum warahmatullahi wabarakatuh. In the purpose to complete the civil law subject assignment, I, Zahra, Aulia, and my team are going to present a short discussion about the private law subjects and objects. Here is the preview of the topics. Next, I will continue to the first topic, legal subject. Private law subjects. There are two kinds of legal subjects, person and legal entity. Person as the legal subject of private law is a bit different with person in other law. For example, in criminal law, someone who is considered as the subject is the ones who committed ineligible actions of crime. While in the private law, a person of subject is everyone since their birth until death. Even the babies who are unborn can be recognized as a private law subject according to Indonesian Civil Code or KUH Article 2, Verse 1. Next is about competention. Legal action, such as making an agreement, might be performed by anyone, but the action won't be considered valid if the doer is a person who is categorized incompetent according to KUH Article 1-330. Those who are incompetent to perform civil law action are the minors under 21-year-old, individual under guardianship, and married women with the written details. Next is about curatel. An unlawful act committed by someone is not always causing a punishment to the doer because the doer might be put under the curatel or forgiveness. Curatel is given to the person with some criteria set in the KUH Article 433. They are an adult who is in a continuous stage of simple-mindedness, insanity, or rage shall be placed under conservatorship, notwithstanding that he might have mental capacity from time to time. An adult individual may be placed under conservatorship as a result of improvidence.
Hello, my name is Regina Yovitha Aiko Silvana. I am from Group 1. So, I wanna explain about definition corporation of law. First, the definition. Second, the theory. Third, the sheer corporation for legal entities. First definition, corporation of law. Corporate term, among them, person from Netherlands, persona moralis from Latin, legal person from English, zedelijk lichaam from Dutch. A corporation is an entity as a corporation that conform to the law, has rights and responsibilities, and primarily has the capacity to prosecute and be sued. Corporations are human organizations or groups has certain goals that can bear both right and obligation. So this is the definition from the authorities. This is Mr. Subakti. A corporation at its center can be a body or association that can have rights and perform human deeds, as well as possess his own wealth, can be accused or sued before a judge. From Mr. Ahmad Sumitro in his book Council, offers a legal entity, person that can have personal property rights and duties. Second, theory. First, there are theory of fiction, spearheaded by Friedrich Karl von Savigny. According to this theory, corporations are strictly state-made entities. Such entities are fictitious in reality, but those who live them in the shadows are subject to law that can perform judicial works like human ones. So, second, it is theory of organ presented by Otto von Gierk. According to this theory, corporations are like humans, becoming truly incarnation of law enforcement. The corporation becomes a body that forms the will by means of these organs or organs. Third theory, the theory of world aims, spearheaded by Zweig Vermogen. According to this theory, only humans can be the subject of law. But there are Vermogens that are not a person world, but they are bound by a particular purpose. This world that no one has is bound to this particular purpose is given the name of a legal corporation. Fourth, mutual theory of wealth, appropriate collective theory, presented by Rudolf von Schering. According to this theory, the right and obligation of corporation are essentially the rights and obligation of members together. The world of the corporation belongs together with all its members. Those meeting together constitute a oneness and form a person called a legal corporation. Fifth, juridical reality theory, presented by E.M. Meyers. According to this theory, such entities constitute a concrete, real, intangible reality, not an illusion, but a juridical reality. Third, sure corporation, about material and formal. A material requirement or material, first having this world apart from its members, while separate from the wealth of its member. Second, having a stable common goal, giving that goal is usually well defined and firmly established in the charter of the corporation. Third, there is a self-interest of a group of people in accomplish its purpose. A corporation have their own interests that are protected by the law. Fourth, having a regular organization means that corporation must have organizational managers. Physical requisitio or formula. There is a legalization from government. First, set up with a notary deed. Second, registered in the office of the local court clerk. Third, requesting authorization from the leasing charter to the Minister of Justice and Human Rights. According to Article 1653, BW legal corporation can be divided into three kinds. The first, government held. Second, which is recognized by government. Third, that was set up for a purpose. According to Article 1655 BW, is a civil servant legal entity by government. Fourth, legal entities. There are public person and private person. First, public corporation. Corporation set up by government for the common good, for example, county government or Pemda, state enterprises or BUMN, the Commission on Corruption or KPK. Private corporation. Private corporation by a private entity. For example, incorporate company or PT, cooperation, kooperasi, CV, firma, political party or partai politik. Thank you, that's all for me.
Before we start to tell about private law object, I want to introduce myself. My name is Radhitya Pratama. My student ID 8111421016. In this topic, I want to tell about private law object. What about private law object? What is private law object and what is like private law object? Before we tell about private law object, we must know about what is object of law. So, Dr. Anus Christine Esti Kansil in her book entitled Pengantar Ilmu Hukum dan Tata Hukum Indonesia explain legal objects are everything that is useful for legal subjects, humans and legal entities, and which can be the objects of a legal relationship, namely rights. In civil law, the object of law is objects, namely all goods and rights that can be owned by people. What is object? Yeah, according to the Great Dictionary of the Indonesian Language or KBBI, objects themselves have the meaning everything that exists in nature that is tangible and has a body. Professor Subekti Esa, from his book Pokok-pokok Hukum Perdata, explained in general, objects or zaak in Dutch are anything that can be judged by someone. This means that things as objects rather than subjects, namely people in law. In addition, objects can be intended as visible goods. Several features who expert in this formulate the meaning of things as objects of law are Professor Subekti, Professor Sri Sudewi Masmun Sofwan, and Professor Sudirman Kartohadi Projo. Professor Subekti ever said about the meaning of object. Everything that people can judge, hear, things means object as opposed to the subject or person in law. According to Professor Sudirman Kartohadi Projo, objects are all tangible goods and rights except property rights, while material law is all the legal rules that regulate what is meant by object and regulate rights to object. There is also an understanding of object and goods. From the expert point of view, this is in line or accordance with what is explained in Article 499 Burgerlijk Wetboek or the Civil Code of Indonesia. According to the law, goods are everything object and every right that can be the object of property right.
There are several types of object according to law. Number 1, things that can be replaced and things that can't be replaced. Next one is items that can be traded and non-tradable or outside trade items. Number 3, divisible and indivisible object. And the last one is movable and immovable object. Next, we'll talk about material rights. What is material rights? A material rights or a zakelijk recht is a right that gives direct power over an object which can be defended by everyone. Material rights in Burgerlijk Wetboek are broadly divided into two. First, material rights that provide guarantees, zakelijk zekerheidsrecht, and the second one is material right that provide enjoyment or zakelijk genotsrecht. Material rights that provide guarantees, zakelijk zekerheidsrecht. Number 1 is pledges. According to article number 1150 Burgerlijk Wetboek, pledges is a right obtained by the creditor on a movable property which is handed over to him by the creditor or by his proxies as collateral for his debt, and which authorize the creditor to take repayment of his receivables and the goods by prioritizing other creditors, with the exception of the cost of selling as the implementation of the decision on the claim regarding ownership or control, and the cost of salvaging the goods, which are issued after the goods are pledged and which must take precedence. And the next one, number 2, mortgage. According to Article 1162 Burgerlijk Wetboek, mortgage is a material right on immovable property, which is used as collateral in the settlement of an agreement. Material rights that provide enjoyment, zakelijk genotsrecht. Number 1, possession. According to article number 529 Burger League White Book, what is meant by possession is the possession of controlling or enjoying an item that is in one's control personally or through the intercession of another person, as if the item was one's own. And number 2, ownership. According to article number 570 Burger League White Book, ownership is the right to enjoy an item more freely and to act on it completely freely, as long as it doesn't conflict with the law or general regulation stipulated by the competent authority and as long as it doesn't interfere with the rights of others, all of which doesn't reduce the possibility of revocation of rights in the public interest and appropriate compensation based on statutory provision.
Alright, now I want to continue my group's presentation, which the material that I'm bringing is about the case example, land sale fraud. The tragedy began when a 70-year-old lady named Arpah tried to sell her land to a man named Abdul Qadir. The soon-to-be sold land is a land with a size measuring from 196 meters out of total area of 299 meters, which leaves 103 meters of land remaining. At first, the remaining 103 meters of land was not planned to be sold by Arpah, but an unfortunate tragedy struck when Arpah was lured to go out with Qadir. Qadir took the chance to take Arpah to the notary's office. With Arpah's unawareness of what happened, suddenly Qadir handed over the deed of sale and purchase from the remaining of 103 square meters of land. Due to Arpah illiteracy, Arpah can only obey and accept when she was asked to put her thumbprint on the letter. With the addition of 300,000 rupiah worth of snack money given to Arpah, Qadir escaped without even condoning to even pay a penny for Arpah's remaining 103 meters of land. When she realized that she had been scammed by Qadir, Arpah immediately reported the unbearable tragedy to the local police precinct. Shortly after, Arpah files a lawsuit towards Qadir. Then, he was named as a suspect by the Depok Metropolis. After that, series of trial at the Depok District Court began. On the February 12th trial, for example, Arpah said that she has received 3,000 rupiah from Qadir without her or her husband proposing on any demand whatsoever. But instead, he said that Qadir gave it to Arpah as a cigarette money. Qadir also denied the fact that he's the one whom gave the money. He also pointed the accusation toward Mr. Yusuf by accusing Mr. Yusuf as the one who asked Qadir for the cigarette money. The fierce debate between Arpah and Mr. Yusuf versus Qadir is continuing, until finally Qadir was sentenced to 8 months of jail for the act of fraud done to Mrs. Arpah and her husband. But sadly, Arpah and her husband still have not yet received their rights on the ownership of their land. The Assembly of Judges are agreed that Qadir has violated the Criminal Code on Article 378 regarding the act of fraud on the remaining 103 meters of land, which was previously self-proclaimed by Qadir from the previous act. Behind the unfairness of Qadir's verdict, the Assembly of Judges ironically put Qadir's good behavior as their deliberate consideration on sentencing the unethical short sentence of imprisonment. Rather than giving the land ownership back to Arpah, the Assembly of Judges ludicrously transferred the ownership back to Qadir. Concerning with what happened, Arpah's legal counsel, Daniel, starts to questioning the judge's action toward the ridiculous decision that they had made. Daniel thinks that this case was proven to have all the requirements to be categorized as an act of fraud. As the episode of trial continues, Arpah and her lawyer, Daniel, keep on standing their ground for the next upcoming series. They then even bring the case up to the civil court, and now they are waiting for the final execution done by the judges. Daniel said that he and Appa are very thankful and satisfied as the case turned tables against Kadir, with Kadir's sentence was increased by 1.5 years. Finally, Arpah and Mr. Yusuf got back their rights to the 103 matters of land ownership. As the story ends, we can conclude from this case example that the subject of law is included as Mrs. Arpah as plaintiff, Abdul Qadir as Qadir or defendant, and then Mr. Yusuf as Arpah's husband, and then Daniel Suciadi as Arpah's legal counsel, and then local police precinct, Depok Metropolis, the Assembly of Judges, and Depok District Court. And the object of law is land sale fraud.
After the explanation about subject and object, now we want to tell conclusion. A law consists of a subject and an object, including private law. Person and legal entity are the subject of private law. Well, the object of private law according to Professor Subakti is everything that people can judge. Here means object as opposed to the subject or person in law. The legal system used to regulate the law of material is a closed system. A closed system is when people can establish new material rights other than those already stipulated in the law. So, the person can only hold limited material rights to those that have been stipulated in the law. For reference, subject and object of private law are fully discussed in the book 1, individual, and book 2 is property of Indonesian Civil Code. That's enough video presentation from group 1. I'm Radhitya Pratama. Want to thanks to Miss Ma'am Dr. Sang Ayu Putu Rahayu SMH. Thanks to the group members namely Zahra, Aulia, Rahim, Regina, Aiko, Silvana, Handaru, Ahmad, Musyaffar, and Muhammad, Rokhi, Nazhir, Fauzi, and Radhitya Pratama. Thank you friends for watching the video presentation well. That's all. Wassalamualaikum warahmatullahi wabarakatuh.